My name is Andrea Bjorklund. I teach at the McGill University Faculty of Law. It's my pleasure to moderate this panel on whether TTIP needs investor-state dispute settlement. We're going to try very hard to have a vibrant, interactive discussion and to cover several issues for you this morning. So I will introduce each of the panelists very briefly now and invite them to get started. We have four main sections, I would say. We're going to talk about the role of investor-state dispute settlement generally. We're going to talk about concerns about investor-state dispute settlement, concerns or alternatives to investor-state dispute settlement, and then, assuming we have time, thinking more broadly, what the alternatives are to investment treaties themselves, not just to dispute settlement, but to treaties themselves. We will, each panelist has something to say about each of those subtopics, and at the end of each section, I'll invite some questions from the audience so that we can involve you in the discussion as well. So our panelists in alphabetical order are Mark Cantor, who is known to many of you. He's a retired partner from Milbank, Tweed, Hadley, and McCloy, where he worked in a lot of project finance. He serves as arbitrator and mediator in commercial and investment disputes. He's editor-in-chief of Transnational Dispute Management. He is an expert in so many areas that I'm reluctant to name only one, but his book on valuation in arbitration is indispensable, and I commend it to your attention. Next, we have Ursula Kriebom, who is Professor Dr. Ursula Kriebom. She teaches international law at the University of Vienna. She is an expert in international investment law and in human rights law. She's a member of the Permanent Court of Arbitration and an alternate member of the Court of Conciliation and Arbitration in the OSCE. She has written excellent articles on all manner of things. Her regulatory takings article in particular is terrific. On my right is Simon Lester. He is a trade policy analyst at the Cato Institute's Herbert A. Stiefel Center for Trade Policy Studies. His research focuses on WTO disputes, regional trade agreements, disguised protectionism, and the history of international trade law. He's worked in private practice. He's also worked as a legal affairs officer at the Appellate Body Secretariat of the WTO. He has multiple publications, is co-author of a very good casebook on world trade law, and is founder of the trade law website, worldtradelaw.net. Next to him is Jason Yaki, who is associate professor at the University of Wisconsin. Jason is a lawyer and a political scientist. His areas of specialty are international investment law and administrative law, and the intersection between those two areas. He is a thoughtful scholar in all of these areas, and he has also brought his empirical expertise to bear in the study of whether and how investment treaties actually encourage or flows of foreign direct investment. So with that, we'll turn to our first topic, the role of investor-state dispute settlement. The first question goes to Simon Lester. In the international investment law system, we seem to be operating under assumptions about how governments act, perhaps based on events that took place many decades ago. Wouldn't it make sense to study the issue today, catalog the problems that currently exist, and develop a system that addresses those problems based on that evidence? Simon.
Thank you, Andrea. So as you can tell from my bio, I'm really more of a trade law person. I still feel like kind of a novice in international investment law, and that was made clear to me because before the panel started, Jason and Mark were talking about a case, and I was thinking, I don't know what that case is. I've never heard of that. So I'm somewhat at a disadvantage here, but I'm bringing to you, I think, the trade law perspective on this. And so for me, as a trade law person, international investment law is a little bit hard to understand. In trade law, I can see very clearly what the problem is that we're dealing with. You have in countries' laws, you have tariff schedules that are hundreds of pages long with thousands of tariffs set out there. And I can explain to you very clearly why I think those are a problem. And then beyond that, there are anti-dumping measures. There's just a variety of specific government acts that I see as a problem, and I think we need to deal with through international agreements. In international investment law, I'm a lot less sure what the problem is that we're trying to fix. Now, there are some obvious possibilities out there. I think the three main ones might be expropriation or discrimination against foreign investors, or this vague and amorphous other category of arbitrary or outrageous conduct by government. So let me just go through each. So with expropriation, I've looked for data on how often expropriation occurs, and there's an economist in New Zealand who's tried to gather this. And it looks like from the 1950s through 70s, there was a lot of expropriation of foreign investment going on, 20, 30, or 40 expropriations per year. And in the 80s, it kind of stopped. It dried up. There was maybe 2 or 3 or 4 per year. And his data goes through 2006. He's doing an update, and I think he suggested there might be a few more these days. But still, it's not that much these days, and it's only in a few places. With discrimination against foreign investors, I suppose this might be an issue, but generally what I see in foreign investment is subsidies for foreign investors, favoritism to foreign investors. Everybody wants foreign investment these days, so it's a very different world than, say, in the 1950s, 60s, or 70s. So overall, it's not clear to me that these two are a widespread problem today. Now we move into the big one, this fair and equitable treatment category, this kind of general category of bad government conduct that people have trouble defining, but they're sure is there. And they refer to all kinds of government acts here. We've got antitrust enforcement, failure to protect intellectual property, basic contract issues. And we've created this really general standard that varies a lot depending on the treaty and the tribunal to apply to it all. But people still have trouble explaining what types of actions it's supposed to cover. So I'm left wondering, with all of this, what exactly is the problem that we're trying to fix? And the obligations we have don't seem well calibrated to address any specific problem. So to me, as an outsider, again, it just seems to me that for this system to work, what people in the system need to do is catalog the problems that are out there and then try to figure out how to design a system that responds to those problems.
Thank you. Reaction? Mark, Ursula?
I think people have been cataloging these problems for many decades, suggesting that we go back and study. Well, we all live inside Washington, D.C. We're inside the Beltway people here, at least some of us on this table. We know what a proposal to study an issue further means. It means you put it on the back burner. There have been academic studies, there have been government studies, there have been conferences over and over again, there have been meetings, there have been treaties negotiated on this point. I really don't think we need a lot more studies. What do we know as a factual matter? Well, we know that direct expropriations went through a strong period in the 1960s and 70s. We know they then dropped off significantly. We know they have begun again in the late 1990s and the last decade and the last few years of this decade. One need only speak with the government of Venezuela or the government of Bolivia or the government of Ecuador, which are quite direct and upfront that they have been implementing programs of expropriation. One need only read the legislation enacted by the province of Newfoundland and Labrador that became the object of the Abitibi-Bowater case, which directly described the conduct as an expropriation, directly stated that the amount of money that would be paid was entirely in the discretion of the province, and directly prohibited judicial review of either the fact of expropriation or the sum to be paid. There's a fair number of direct expropriations. In addition, there are a large number of claims of regulatory expropriation, indirect expropriation, what we, under the Fifth Amendment here in the US, refer to as regulatory takings. Are they successful? Well, usually they are not, in fact. The track record under NAFTA is pretty darn clear. I don't have the numbers memorized, and you talked just a little too fast, Simon, so I couldn't pull it up on my computer. But I think there's a fine report by two good scholars that said that the question of of conduct tantamount to an expropriation, which is the language employed in NAFTA to deal with indirect expropriations, regulatory takings, was asserted roughly 18 times in NAFTA cases up through, I think, 2012, and successful once. So there are a fair number of claims, not too many successful claims, at least against Canada and the United States and Mexico. When you look outside Canada, the United States, and Mexico, well, there you often see rather higher number of successful claims, although still states win far more often than investors win. But I would just remind all of us that we not too long ago saw an award against Russia for a claim that was an expropriation claim, an unlawful expropriation claim, and the award was the small sum of $50 billion, the Yukos case. So I do think we don't need more studies. We need to focus on the fact there is an issue here. People can disagree about whether the issue is bigger or smaller, but I really wouldn't recommend we put it off to one side and assign it to a committee to study.
So I cannot but agree with Mark Cantor that we do have an issue. And actually, if you see that there are around 300 to 400 cases which have been brought under investment law in last 20 years, you can see that if the whole thing is to be meant as, so to say, a minimum guarantee, if an investor feels that in the national arena they cannot achieve what they should achieve, mainly a fair remedial system, then I would not underestimate this amount of case law. If you compare that to the European Court of Human Rights, from the 1950s to the 1990s, we had about the same amount of judgments out there, and nobody was questioning whether we would need a court protection system of human rights. I mean, these days, the dimensions are totally different, but that's because of some of the states which acceded to the Council of Europe. But exactly these states are also those which are potential partners in bilateral investment treaties. So this is not a system which is only made for well-functioning democracies. This is a system we find in around 3,000 treaties where you have treaties between countries of all different types.
Jason? Jason, do you
have? So I wanted to just to start off before pushing back a little bit on Mark's point. He might get a lot of that today, I think. It's still a fair panel. But so this idea of TTIP and ISDS being controversial, in Europe it has been enormously for the past year. I think that the Europeans in the audience know that. In the US, as of last October when I gave a similar talk to this one, it was not in the news whatsoever in the US, completely uncontroversial, completely under the radar screen. That all changed about a month and a half ago when Senator Elizabeth Warren released a press release, not the most cogent of press releases, but one that attacked ISDS. And it started to pick up steam here in the US, and so this is getting more controversial. I heard my local student radio in Madison, Wisconsin, they usually talk about the Packers. They were talking about ISDS and complaining about it, which was quite incredible just last week. So it's really a hot topic. I find myself really, I think, agreeing more with Simon than with Mark, and that I don't think we've actually done in the debate, actually done a good job of articulating what the problems are that ISDS is meant to address in the specific context of the EU-US relationship. And so just briefly, I think there are a couple of ways of thinking about the potential problems. You guys know about ISDS and what it's supposed to do. One thing it's supposed to do is to promote foreign investment flows. And I can't say, this is for the economists, whether we need more foreign investment between the EU and the US. I don't know. But as a descriptive matter, it is certainly true that we have, right now, without ISDS or even TTIP, enormous amounts of investment flowing from the US to the EU and vice versa. And so if it's a lack of foreign investment that is the problem we're trying to solve, I mean, to me, it looks like we got a lot of foreign investment. And so I think that's a relevant point. The other problem we could be trying to solve is, I think, a problem of just generally mistreatment of foreign investors by EU domestic legal systems or US domestic legal systems. And there, I mean, I think that the proponents of the people that are really pushing hard to include ISDS in TTIP have not really risen to the challenge of identifying concrete instances of what I would call sort of systematic or systemic mistreatment of foreign investors. And so let me give you an example of the case that's often brought up. Well, I'll mention one of Mark's. A bit of Bowater did not involve the EU, right? Russia, not, as far as I know, God, that'd be interesting, not part of TTIP. So what are the cases in Europe where US investors have been mistreated in a way that would be likely to be addressable through ISDS? The US, the Europeans say, oh God, that Lowen case, that shows how corrupt the US judicial system is. And I always laugh at that because that's a case in which the investor lost. And so how can you hold up ISDS as a way to protect investors using Lowen? You might use it to illustrate some bad things about jury trials in Mississippi, but if you start advertising ISDS as a way to get around the constitutional right to a jury trial in the US in civil suits, I think that ends up being really sort of, not a great argument. So anyway, I think that Simon's right, actually.
1 minute. Okay. Oh, sorry, do you want to say something?
Can I say something quickly?
Very quickly.
So Mark mentioned some data, and I think we actually agree on the data, but I think we would characterize it differently. So it sounds to me, he'll mention Venezuela, Bolivia, Ecuador, and Canada as cases, instances where there are expropriations. So it sounds to me like there are only a handful of countries where this happens, and it's very rare, so I'm not sure why we need thousands of treaties to deal with it. But the big issue really is fair and equitable treatment. What is this supposed to cover? Antitrust actions, Supreme Court redefinitions of software and gene patents, every government action or inaction? I think we need some more clarity.
All right. Next question. Based on picking up on something Jason has already mentioned, does investor-state dispute settlement and do investment treaty protections have any verifiable positive impact on the attraction of investment? Mark.
Do put a placekeeper in so I can respond to the question of why Europe. But
we're going to get to that.
I understand, we will. The answer to the question, do investment treaties have a positive impact on investment, is something that our friends in the economics and political science world have actually studied at fairly great length. The most recent study on that was done by Jennifer Tobin and Mark Bush, who teach here in Georgetown over in the main campus in political science and international relations. Let me just summarize briefly what they had to say rather than boring you. They have a wonderful little chart for the PowerPoint they do, and they did this PowerPoint for IBA Arbitration Day here in Washington in February. On the left-hand side, in a chart entitled Interpreting the Evidence, it says, some studies say no, weak or no correlation, or problematic correlation, in other words, a negative correlation, between investment agreements and growth of FDI. Many studies say yes, says the right-hand side of their slide. But you need domestic institutions and other international factors. And what that means is a perfectly common sense idea. consistent, for example, with the volume on this subject that was edited by Carl Savant, which is that on a standalone basis, investment agreements probably don't have a measurable positive impact on attraction of investment. However, together with other steps to promote and protect investment, they are an element that achieves a positive result if your objective is to attract foreign investment. And those other steps are both domestic and international. They involve such things as, well, having a Bill of Rights, for example, having an independent judiciary, for example, having other international agreements, being part of the WTO web, entering into free trade agreements with your neighbors. All of those things collectively impinge upon the consciousness of someone who is seeking to make an investment. It is highly unlikely, for example, that any European companies, in assessing whether or not to make or expand an investment in the United States, say, oh, well, I know that the Fifth Amendment provides compensation for a taking. I know that the Fifth and 14th Amendments provide for procedural and substantive due process, even if substantive due process is a highly deferential standard. I know the 14th Amendment provides thou shalt not discriminate, equal protection, race, creed, color, sex, and national origin. I don't think there are very many European investors who really know what the US Constitution has to say. And candidly, I doubt there are very many European lawyers who know that either. But they do have a generalized, non-discrete notion that the US is a relatively safe place for investment. And one of the things contributing to that is the US Bill of Rights. Much the same thing applies for countries that don't have bills of rights, but have investment treaties or the European Convention on Human Rights. Investors don't focus on one particular instrument. They cannot describe that particular instrument in any concrete legal fashion the way this audience could. But you know, you're not an audience of investors. You're an audience of experienced international lawyers. You know those boring details. Most investors don't. They do have a generalized notion, though, of what attracts them. And the studies do suggest that those generalized notions include things like investment treaties.
Yeah, I mean, I guess I would just appeal maybe to the collective wisdom of crowds, and I would ask the audience just to think in your heads, not to say it out loud, but I mean, is it plausible to you that there are Europeans who are currently withholding investment from the US because they don't have the protections of an investment treaty? And I think that, I'm guessing, most of your heads are probably saying, well, that seems pretty implausible. And I think that I have the same sense going the other way for most European countries. Now, we certainly have Eastern European countries where the rule of law, however you measure it or conceive of it, is weaker. But for a lot of Western Europe, I mean, I just view this as, I don't see the theoretical sort of case here that it really matters. And so the UK, Germany, France, maybe what's holding you back from investing in France is that once you hire a worker, it's impossible to get rid of them. I think that's a very serious concern, right? But ISDS and an investment treaty is not going to help you with that problem. And so I think the things holding back investment between the EU and the US maybe are related to sort of market liberalization and that kind of thing, which is a completely sort of separate issue from ISDS. And so I sort of disagree with Mark. And recall too that regulatory expropriation, that's the big bugaboo here. But as Mark said, most of those cases are lost in ISDS. So even there, I'm not convinced.
I would say that TTIP is just one example of an investor-state arbitration providing treaty. And we discussed this question later on, yeah, but I think we should not lose sight that it might have an impact if we don't include it here, because we would have to make judgment that other states are less good than the EU and the US are. Number two, apparently the United States government thought that it would need to protect US investors in some Eastern European countries. Otherwise, you could not explain why they concluded bilateral investment treaties with those countries. And if you look to the case law in investment arbitration, you would find out that there is a number of cases which these countries have either pending against them or have lost. And if you look at the European Court of Human Rights case law, you would find that the same countries have lost quite a number of cases which are either related to protection of property or protection of fair trial.
Andrea, if I could just follow up on one point there. Jason poses the question starkly, do you have investment or don't you? In the real world, it isn't just whether someone says, yes, no, I will make an investment. It's also the cost of that investment, the terms of that investment, and the margins, whether or not the investment reaches the internal rate of return that's set by the investor so that it justifies making the investment. I, unfortunately, in the days when I was a practicing lawyer and involved with business transactions, not litigation, I knew a fair number of potential foreign investors in the US, mostly from Japan. My partners dealt with the European stuff. I dealt with the Asian stuff. I knew a lot of them who were very troubled by the US court system, thought it was nationalistic, thought it discriminated in favor of Americans, thought it was enormously expensive, thought it had erratic decision-making, and it did affect their willingness to invest in the US. At a minimum, it required that they set a higher internal rate of return. At the margin, of course, that means some investments don't make it, but mostly it was a lot of sand in the wheels to an effective investment. And from a macro perspective, that's really important. That's jobs, and jobs matter.
Just a quick point. It seems like we're discussing this question as in terms of if we want to attract investment, we can either have ISDS or we can have nothing. And I just want to, we're going to talk about this more later. There's another option, which is we can have state-to-state dispute settlement system, and I think that would work pretty well. But we'll talk more about that later, I think.
Okay. A next question for Ursula. Is ISDS beneficial or dangerous for the rule of law, both in the international and the national spheres?
The rule of law today is a concept used by many and in many different ways. We do not have the time to enter into a debate what exactly should be understood by it. Only if you understand by the rule of law the preeminence of national law, whatever it says, ISDS would then be bad. However, if you define rule of law as giving preeminence to predictable rules, due process and transparency, ISDS is clearly beneficial in the international and in the national sphere. Let me start with predictability of the content of the international standards. 3 options exist to achieve predictability of the normative content of the international protection standards. The original choice of states creating investment protection treaties was to opt for rather general terms and leave it to the case law to specify them. This has led to the development of a number of criteria by tribunals, for example, for explaining what fair and equitable treatment is. Although some of the criteria were regularly followed, we can also witness that there is conflicting case law, for instance, on MFN or indirect expropriation. Therefore, more recently, a number of states, among them Canada and the United States, have adopted definitions. Examples for this approach are definitions on the method and how to establish an indirect expropriation, and the inclusion of a regulation exception with regard to indirect expropriation. The EU and Canada have followed this approach in the CETA text, and the same is true for fair and equitable treatment, where they applied the same method and now defined the standard by including a list of acts that would lead to a breach of the standard. It is likely that the negotiators in TTIP will follow that. A third option, which we will discuss later, is an appeals facility. To achieve predictability, it would, however, be necessary that there is only one appeals facility for all the different investment protection treaties. Let me now turn to predictability of government conduct as a requirement introduced by the international standards. Government actions should be bound by rules fixed and announced in advance. In general, it's the aim of standards like FET, expropriation, food protection, and security to ensure that coercive power of governments is only used in a specific way. For example, expropriations are only against compensation, or arbitrariness and abusive treatment is prohibited. Next, due process in arbitral proceedings requires inter alia independence, impartiality, and avoidance of conflicts of interests of arbitrators, equality of arms, and reasoned awards. Investment arbitration provides for mechanisms that allow for a review of due process in arbitral proceedings, challenges, setting aside proceedings in non-ICSID arbitrations, annulment proceedings in ICSID arbitrations. Due process is also a requirement introduced by the international standards of investment treaties. In that way, ISDS is a guardian of due process by national authorities. It's part of the FET standards. It's sometimes also seen as a requirement under the expropriation standard. Next issue of rule of law is transparency. Transparency of investment arbitration is a topic which still attracts a lot of attention, although many efforts have been made to ensure transparency in investment arbitration in recent years. With regard to CETA, the antitrust transparency rule apply, and hearings will be open to public. And if you look at NAFTA, we could claim that you have much more transparency than you would have in any Austrian court proceedings or administrative law proceedings. We also find transparency as a requirement introduced by the international standards. So for instance, if you look into the FET provision in CETA, it speaks of transparency in judicial and administrative proceedings. Thank you.
So in terms of the rule of law, so no offense to the people who work within the system, but as an outsider, it doesn't seem to me that this system ranks very highly on the scale of rule of law. For one thing, the fair and equitable treatment obligation, which I'll keep harping on because it's important, different treaties and awards say very different things. It just seems like there's 5 or 6 conceptions floating out there. There's just no clear sense of what this is supposed to mean and what it does mean. In addition to that, on national treatment, I mean, I find some of the interpretations of it really strange and odd. There are things that used to be in WTO law, which we've gotten rid of, I hope, but they're still there. And in my opinion, you can find discrimination where it actually doesn't exist based on these rules. So I think we're 50 years into the system, and I think it lacks clarity and common sense in many ways. Then there are all the procedural criticisms, lack of appellate process, the way members of the tribunals are selected. I think if we want this to be something that people can point to as something promoting the rule of law, I think these flaws have to be fixed first.
Well, that assumes that all of those treaties other than the ones that the United States has entered into since 2002 are part and parcel of this confusion over the meaning of fair and equitable treatment. There's clearly no doubt there are a lot of different meanings offered. But one of the things we've seen as a really clear development in the last 12 or so years is a deliberate effort by the United States, starting with an interpretation of NAFTA in 2001, continuing with treaties that were renegotiated in 2002 after the Trade Promotion Act was enacted. And every treaty entered into by the US since then, and both model bilateral investment treaties, that narrow the discretion of the arbitrators, seek to identify the source to which the arbitrators must look to try to understand the meaning of fair and equitable treatment. Has that worked? Well, in general, investors have had a pretty rough time in the last 12 or 13 years under NAFTA proceedings, although earlier this past month, the Bilcon investors succeeded on that claim against Canada. There are clearly still differences when one looks at the NAFTA jurisprudence, but they are narrower and narrower. Far and away, the biggest issue today is whether or not the standard evolves from the way it was understood in 1926 in the near decision of the Mexico-US Mixed Claims Commission, and whether it should take account of changes in understanding culture and society. That, of course, is a dispute that's mirrored in the US Supreme Court and has been for many, many years between the originalists and the people who believe in a living, breathing constitution. So I don't think that dispute is unique to the world of investor-state arbitration. But I really do believe strongly the right way to look at the uncertainties in this system is not to look at the 1980s and 1990s era treaties. The US has turned its back on those treaties for treaty drafting purposes. The European Union has turned its back on those treaties for treaty drafting purposes. One need only look at the EU CETA or the EU Singapore agreements. I don't think you can draw many conclusions about the prospects for uncertainty in TTIP from agreements the US and the EU have turned their back on.
Just wanted to make a short remark. I think it's a tremendous chance for the United States and the European Union if they now include, for instance, a FET provision similar to the one you would have in CETA. Yeah, you can disagree or agree with the exact wording, but this would be two blocks of democratic states which would have the possibility to lead by example and clarify what that standard could be, and to clarify it in a much more concrete way than to link it to the international minimum standard, where again you could discuss what is the international minimum standard. So, and I really think that's an opportunity.
So picking up on a point that has already been mentioned, but what kind of signal does it send if investor-state dispute settlement is kept out of investment protection treaties between developed countries and is only incorporated in treaties with developing countries? In particular, would excluding ISDS from TTIP harm the US and EU bargaining positions in future negotiations with China? Jason.
Yeah, sure. This is an interesting question, and it's one that I was at the receiving end of a few years ago when I did a report on ISDS and TTIP for the UK government. So the argument is that if we don't put it in TTIP, then we're never going to get it with China, and we need to get it with China. And I would agree that the case from the U.S. perspective, U.S. investor or EU investor's perspective looking at China, the case for ISDS with China is stronger than it is in EU-US FTA, for sure. Although you have to ask yourself, how realistic is it to think that foreign investors would sue the Chinese government, given the role that the Chinese government plays in the economy? It seems like you sue the Chinese government, you're kind of done in China. But the case is stronger for ISDS in a treaty with China. On the other hand, I mean, the idea that if we don't put it in TTIP, that the Chinese aren't going to agree to it, seems really strange to me for a couple of reasons. Well, one, the Chinese seem to really want ISDS, right? They have 160 investment treaties. And so I don't think that they need to be convinced to put ISDS in the treaty. But the second reason, which I think is really sort of more powerful, the more powerful counter-argument to this counter-argument against taking ISDS out of TTIP, is that we know what China's going to do when it negotiates in FTA with a country that has refused to put ISDS in FTA with a developed country, right? And so we have the Australian case. Like, the Australian case just demolishes this argument because, you know, US and Australia, as you guys know, don't have ISDS in the Australia-US FTA. But what do we know about the current negotiations for the Australia-China FTA? I just checked last night. You know, the investment policy of Australia is a bit incoherent across time. But according to the website, they still are very much intending to put ISDS in the FTA with China. So no problem getting China to agree to it. So to me, I think the Australia example is really sort of like the nail in the coffin of that idea. I think it's irrelevant to our negotiations with China, what we do with ISDS in the TTIP case.
Mark, I mean,
well, if Simon or Ursula wishes to say something, I talk too much, but I do have things to say on this. But please go ahead.
I have one quick thing. I agree with everything Jason said. I just want to offer a perspective from the trade policy world. China is constantly demonized out there. Everybody's afraid of China. So when I hear talk of a U.S.-China bilateral investment treaty, it would just shock me. I mean, you could negotiate one of these, but if you brought it before the Senate, somebody would point out that this means Chinese companies can sue the U.S. government in an international tribunal, and I feel like, well, that would be the end of that.
Quickly.
Go ahead.
A very quick comment. Actually, there's one thing to think about China, but I mean, if we look at all the treaties out there, there are many, many treaties out there with developing countries. So if we now say this system is so dangerous or unequally balanced or whatever, so that we don't want to include it in a treaty between the EU and the US because we fear that investors could get remedies they shouldn't get, how do we justify that we find that same system is just vis-a-vis the developing world? I mean, we could say, yes, we can impose it on African countries because they need our investments and they have to agree to this treaty and our negotiation leverage is better than theirs, so we will somehow manage to achieve that. But from a justice perspective, I find it difficult to argue why these countries should find that just and balanced for them if two democratic blocks of states cannot manage to agree on a system they find fair and appropriate for them.
We actually know the partial answer to Jason's question. On March 9th, the Ministry of Commerce in China announced that the text of a bilateral investment treaty with the United States had been agreed, and that the two countries were now negotiating the terms of the, quote, negative lists, unquote. Those are the appendices to the treaties that identify exclusions from the most favored nation and national treatment obligations in the treaty. We also know that the United States, following a multi-year review of its investment treaties, the Obama administration concluded that it would keep investor-state arbitration in its investment treaties. And we know that the Chinese government has been insisting on investor-state arbitration, in part because the Chinese government feels very strongly that its nationals and its state enterprises have been very badly treated in the United States, and it wants independent and impartial tribunals. So we can predict, I think, with 99.9% certainty that that unreleased text includes investor-state arbitration. What we can't predict, though, is what will happen in the EU-China negotiation. The EU, at the same day the Ministry of Commerce announced that the text had been agreed with the US government. The US government, by the way, has said nothing about whether that's an accurate statement. But the Chinese ministry also said that it had received the text for a potential investment treaty from the European side and was preparing its response to that. If the EU does not go forward with investor-state arbitration with the United States, I suspect that will be a very interesting negotiation between the EU and China. And as to whether it's at all realistic to think that this plays into these negotiations, my gut instinct the first time I heard the argument was, oh, come on, that can't be right. What gave me pause and continues to give me pause is treaty negotiators from both the United States and the European Union insist that what happens in TTIP will affect the negotiations with China. Now, in the case of the US, that was largely determined by the Trans-Pacific Partnership, where the information that there would be investor-state arbitration, except maybe Australia, has been well known throughout Asia for a long time now. And the leaked draft from January shows that other than Australia, it's pretty darn clear we're going to have investor-state arbitration in TTIP. So in TPP. TPP send big signals to the Chinese. TTIP will come along after the Chinese and the US have agreed the text and it's become public.
Okay, I think we'll move directly to our second topic. We're already a little bit behind schedule. The topic is concerns about investor-state dispute settlement. First question, do investor-state dispute settlement proceedings have any verifiable negative impact on host state environmental, labor, or health and safety regulation? Ursula.
Thank you. To start with, investment arbitration does not pit investor rights and environment against each other. Tribunals in general do not weigh between investor rights and the environment. The function of ISDS is entirely different. The host state's right to legitimate regulation in the public interest is undisputed. The function of an investment tribunal is to examine whether, in a particular case, a regulation was, in fact, legitimate. That determination cannot be left to unilateral decisions of the state that is accused of abusing its regulatory powers. The possibility to subject laws or administrative acts to control is an indispensable component of the rule of law. However, regulatory chill is increasingly seen as a consequence of investor-state arbitration. The regulatory chill argument is based on the assumption that states, if only left alone, will always do the right thing and will invariably act in the public interest. I regard this assumption as questionable. Regulatory chill is typically seen as a state actor failing to enact or enforce bona fide regulation measures because of a perceived or actual threat of investment arbitration. But the chilling effect may also be beneficial. The chilling of discriminatory, protectionist, or arbitrary regulations or enforcement is the very purpose of investment protection. Therefore, of concern are only situations where bona fide regulatory measures were prevented. Researchers have recognized that regulatory chill does not lend itself to statistical analysis. Therefore, we are often left with anecdotal evidence and case studies. The problem is that even with case studies, there are no smoking guns which indicate why a particular government stopped a certain initiative. But it cannot be excluded that the threat of an ISDS case contributed to a change in the government's position. But usually that's a multitude of factors, and causality is very difficult to prove. In a study published by Cattle and Jensen in 2014, they show that of all concluded exit decisions, 47% were associated with the conduct of ministries or agencies, while only 9%, namely 14 cases, resulted from legislative acts. They conclude, given the low rate of disputes involving legislative branch activities, arguments that investor-state arbitration may encroach on the legitimate prerogatives of domestic governments appear to be overstated. Instead, democratic legislators should embrace investor-state arbitration as an additional check on executive behavior. Moreover, if you look to the NAFTA cases that did directly challenge legislative acts, and all of them failed. What often has triggered finding of violations were protectionist measures that privileged national investors over foreign investors, but these were measures adopted by administrative authorities. Furthermore, it has now become common practice to include a guarantee of the rights to regulate in investment protection treaties. All of the texts negotiated by the EU Commission contain such provisions. The same is true for all the texts negotiated by Canada and the US after they changed their model BITs in 2004. The right to regulate is included in the definition of expropriation and non-discriminatory measures of general application taken by a party that are designed to protect legitimate public policy objectives do not constitute indirect expropriation if they are necessary and proportionate. One last point. National court proceedings could constitute a much bigger risk of regulatory chill because unlike investment tribunals, national courts can overturn or invalidate government acts in addition to awarding compensation.
Okay, we're going to turn to the kind of next related question before having a little discussion. Mark, do investment agreements have any verifiable negative impact on home state jobs and investment?
You know, Andrea, candidate Obama and his team in 2008 would have said no. In fact, they have a negative impact on US jobs and US growth because you're exporting jobs overseas. President Obama and his team have come to a patently different conclusion, haven't they? We know that. They did not renegotiate NAFTA. They undertook a model bit review that ended up in reaffirming what U.S. investment treaties ought to look like. And they pushed through 3 free trade agreements in Latin America, Colombia, Peru, and Panama that had previously been stalled. So policy under the Obama administration has been quite different from what some of the rhetoric from candidate Obama's team was in 2008. What happened? Well, the financial crisis happened. Because in response to the disasters of fall 2008 here in the United States and the huge economic problems, the Obama administration turned, among other things, to exports as a means to bring the American economy out of the problems created by the collapse of the financial system. And one of the things they discovered is there is a strong and direct association between U.S. exports and the establishment of U.S. investments overseas. Essentially, American companies establish foreign affiliates. They produce goods and services which they then send to those affiliates, which are then incorporated into goods and services rendered by those affiliates, thereby significantly increasing U.S. exports. Now, this isn't just theory. There's a long-standing set of studies demonstrating this relationship. The most recent of them from last year, Moran and Oldensky, writing for the Peterson Institute for International Economics. Let's just look for the moment at the numbers they came up with. For U.S. manufacturing companies, a 10% increase in employment at foreign affiliates, the loss of jobs we all worry about, has led to an increase in R&D spending in the U.S. of 6.2%, of U.S. sales 3.9%, capital expenditures in the U.S. 3.8%, U.S. employment 3.8%, exports from the U.S. 3.8%. All positive. What about services companies, not manufacturing? It's even bigger relationship there. Those of you who work for private law firms understand this. That's why you open foreign offices. R&D spending in the U.S., 10.8%. U.S. sales, 3.6%. CapEx, 2.3%. U.S. employment, 2.7%. Exports from the U.S., 2.0%. And if you measure it not against employment overseas at foreign affiliates, but sales by foreign affiliates of U.S. companies, the numbers in favor of U.S. growth of the U.S. parent, are larger. So this may seem counterintuitive, but that's the relationship the U.S. government realized and determined we needed exports, therefore we have to support investment.
Yeah, so just briefly, I more or less agree with Ursula and Mark. I'll focus on Ursula's comments, though, and leave Mark's aside, because I'm not an economist. But, I think Ursula's she's right that the critics of ISDS, in the same way that the proponents have the challenge of defining the problem that that ISDS and TTIP is meant to address, and they haven't done that, in my view. The critics also have a challenge, and that is to identify the costs or the negative aspects of ISDS and TTIP in a convincing way. And, I think Ursula's right that, as an empirical matter, it's difficult to test the regulatory chill hypothesis, but we also don't even really have any really strong anecdotes to back up the idea of regulatory chill. And so the case that there are immense costs is not as strong as you might think, given statements like Senator Warren's and others from that side of the aisle. On the other hand, we do have, I think, the one elephant, maybe one elephant and something smaller than an elephant in the room, and that obviously is the Philip Morris case, right? That's the big overhang here, and that's ongoing. And so that's a case that I think proponents of ISDS like to not talk about. Tobacco is different, a question we'll talk about in a couple of minutes. But we also have Vattenfall, which my census has been very salient in Europe, and those are ongoing. And so I think that in a way, I think it'd be very interesting to see what happens to the ISDS and TTIP debate if those disputes would get settled in the investor's favor. Now, I think Philip Morris is never going to win for reasons we can talk about. But I think that those have to be addressed. Another issue to think about is that the amount of investment, as I said, between the US and EU is so massive that if you put ISDS and TTIP, it's going to apply to existing investments. You've suddenly given a new right to litigate against the state to thousands upon thousands of investors. And so even if they're not likely to win, you have to ask yourself whether you've increased the chances of investors bringing sort of long shot claims that may, roll the dice, may actually sort of impact, states may lose, states may count on losing, and may impact their regulations. So even though states don't lose these cases very often, there aren't big anti-right to regulate cases out there, a lot of investors are going to be able to sue the governments, and so take that into account. It's not like having an investment treaty with the Dominican Republic.
So that we can have some time for questions, Jason, since you mentioned it, why don't you pick up on your point,
Okay.
about the tobacco case?
Well,
Is it appropriate to deal with concerns about ISDS by carving out specific industries or sectors, tobacco, healthcare, et cetera?
Yeah, this is a really interesting idea. I might have actually been Mark at another conference who brought this up. But the idea that you can deal with certain problematic industries like tobacco, or maybe healthcare, so national health systems is very sensitive, by carving them out. So you have ISDS and you carve out these problematic industries. So I don't know, I heard this rumor third hand, but that the USTR was proposing this as a solution to, I forget, TTIP or TPP. So tobacco is not going to be able to bring investor-state disputes to ICSID, et cetera, right? And that's kind of an interesting solution. We have precursors, and so the cultural industries exception in NAFTA, that sort of thing seems to work relatively well to allow liberalization where it's not controversial by protecting small, relatively unimportant sectors economically speaking. So you could do that. It might be very pragmatic. That solution, I think, though, depends on the assumption that the industries that you carve out, tobacco, maybe health, sort of pose unique problems that other covered sectors don't pose, right? And so, for whatever reason, tobacco is very likely to sue. We hate tobacco. Tobacco's evil. It makes sense. Other industries aren't likely to sue. They aren't evil, et cetera, et cetera. And so I think you just want to sort of think about that. Is tobacco really different? But also, too, I think you have the other idea, which really gets to the rule of law point that Simon's brought up, in that, it's sort of anti-rule of law principles to say that some people have a right and others don't, especially where, tobacco companies are legal. There are a lot of investors, normal people. Corporations are people, as our friend Mitt Romney has said. Even tobacco companies are people. And so does that violate anti-rule of law principles to say, okay, well, tobacco, yeah, not you, but everyone else? So I don't know. I think it's an interesting issue. I think it has lots of problems, though.
Go directly to your question. Okay, because it's so, Jason. Thank you. I'm going to go directly to the next question, and we'll have some discussion then. But that leads right into something that Simon was going to talk about, which was, of all the groups who need and deserve protection under international law, how do foreign investors compare to those others? Is it more important to offer effective protections to them, or say to oppressed minority groups? Why does the existing system, a couple of regional human rights treaties aside, give so much protection to foreign investors while mostly ignoring oppressed minorities? Simon.
So I keep having to qualify my answers by saying I'm not an expert, and that's never a good thing. But I'm not really an international law expert. I kind of got forced to study it when my friend Joost Pauwelen was arguing that international law should be a defense to WTO claims, and I had to sort of sort it out a little bit. But what I see in international law is a general failure to protect individual rights, with this one big exception, that certain foreign investors have these agreements that they can assert their rights, and others just don't have this. So if you're a foreign investor operating in a country that doesn't offer its own rights protections, you have ISDS as an option, but if you're not a foreign investor, you don't. Let me give you an example. This is from a recent Economist article about a Chinese citizen who owned a hotel in China. According to this, so I can't verify this myself, but this is what The Economist wrote, and I trust them usually. So this Chinese hotel owner said he was abducted and held for 13 hours as the building he owned was demolished by what he describes as a network of corrupt officials and developers. All of its contents were lost. He tried to get compensation for this. Local police wouldn't help him. The courts wouldn't help him. The Economist says this story is far from unique. Since the mid-1990s, tens of millions of Chinese have lost their land, and in many cases, only minimal compensation has been offered. So this sort of reinforces my general sense that the people most harmed by government abuses like this are domestic investors, but we don't do anything for them. We only do things for the foreign investors. And then going further, there's the lack of protections for oppressed minority groups, racial minorities, religious minorities. And to really drive that home, I was struck in the CETA ISDS provisions that the language of fair and equitable treatment provides a remedy for ethnic or religious discrimination. But of course, this is only for foreign investors. So it just seems to me that a system that provides this strong remedy for foreign investors and not much of a remedy for anyone else is, if I can use this phrase, it's not fair and equitable.
So I'm going to invoke a privilege to follow up on that. Why is the response to that? Why is the answer to dismantle protection for foreign investors, which might be viewed as something of a race to the bottom? Why isn't the answer to extend protections to domestic individuals, domestic corporations, along the lines of what we've done in the human rights system, so that we have something of a race to the top?
Yeah, that's not a bad suggestion. I don't really hear people, you might be advocating it, but the business groups who support these things don't. I mean, the people with the money and the power are not arguing for that. That it seems to me that is not going to happen. But it's good that I support your argument. But yes, it's not going to happen though.
So I invite the rest of the panel to engage in a little discussion right now, but if there are any questions from the audience, if you'd come up to the microphones and we'll try to work some questions from the audience in as well. We skipped that. We haven't gotten there yet. Okay, I hope so. Any responses from the panel? Shall we?
Questions are fine.
Questions? Ma'am, sorry, I don't.
Sorry. Hi. Miriam Sapiro. I do have some battle scars on this question, having just stepped down as Deputy U.S. Trade Representative, so directing the launch of TTIP and also review of the model bit. Nonetheless, I don't know, is this working? Can you hear me all right?
I can hear you.
Okay.
Yeah.
Nonetheless, I think it's very important now, because of the emotion that has been surrounding this question in Europe and in the United States, that we take a fresh look, not a study mark, but maybe call it a look. And I think the panel's done a terrific job of bringing out some of the arguments for and against. A couple others that I have seen lately I wanted to mention and see if you have any reactions to. So in terms of one of the arguments for having ISDS goes to the inappropriateness of, in a context where a foreigner has a challenge, is it inappropriate for one part of the sovereign government to be asked to sit in judgment on the actions of another? So you may have in the domestic context, but in a foreign situation, do you want an investor, that's what we're talking about here, to be in the situation of asking a foreign judicial organ to review the actions of either the legislature or, more typically, I think, the executive? Another issue that has been discussed is, on the other side of that, well, why do you need this protection when an investor could simply buy political risk insurance? In the US, we have OPIC, and other governments have other vehicles for providing that kind of risk. So Mark made the point about it can change the equation on the margins, but there is the opportunity to do something about that. Going back to the other side of the argument, I think it's also been discussed as to, the notion that foreign investors are getting special treatment is very, makes a great soundbite. But in reality, at least with the U.S., the government's taking great pains to make clear that there are no additional substantive rights. And my sense is Europe has the same position, but it'd be interesting to hear from Ursula if that's indeed the case. And then I'll make just one specific point about TTIP, and that is, it's very easy to say, as Elizabeth Warren, I think, either has or will, when she's finished with her concerns on TPP, it's very easy to say, well, because Europe and the EU and the US have such high standards, we don't really need it in this particular context. In addition to the precedent argument that you set, I think it's also important to remember that the EU has 28 member states at very different levels of development. And I don't want to say this as an American, but tell you what I've heard my European colleagues admit, and that is that they don't have the same level of confidence necessarily going into a court in certain countries that are part of the EU versus other countries. And I think even in this country with 50 states, very diverse jurisdictions, not everybody feels that they're going to get, as a foreigner, they're going to get the same kind of fair hearing that an American investor would. So anyway, just wanted to throw out those points. There are some additional ones, and I know you couldn't get to everything, but in case you have comments on those, I'd be most interested in hearing them.
Could we keep those in mind and collect a few more questions? Charlie?
There's a certain air of unreality about this entire debate because no one has defined the ISDS that we are discussing. The United States has been the leader in deconstructing ISDS as we have known it, at least up until the time of the trilateral NAFTA interpretation of fair and equitable treatment and full security and protection. Mark has alluded in part to the United States model BIT, which withdraws in advance, in some cases, of an arbitration from the investor any ability to pursue its claim. Example one, the treaty provides an expropriation provision that taxation measures can be an object of an expropriation claim. But when you get down to the fine print later on, it says, before you can arbitrate, you must submit the dispute to the competent authorities, which is a term known in bilateral or double taxation conventions. That means the Assistant Secretary of State of the Treasury for tax policy in the United States and his or her counterpart in the foreign country. And if within a stated number of days they decide that that claim is not an expropriation, that's the end of it. You cannot even arbitrate. There are other provisions in Annexes 1, 2, and 3, Roman numerals, setting forth, allowing each state party to set forth a list to which Mark alluded of measures in force in that country which that country withdraws from the protection of the treaty. So there's a wide area within which the unilaterally, the state party says, I'm sorry, but I'm not going to allow the system to deal with the following things that was referred to in the discussions with the Chinese. Now, if a respondent state invokes one of those items in the long list as a defense, bingo, it goes to the two states for an interpretation, and the two states have a period of time within which to issue an interpretation which is binding, which says, yeah, that defense applies. You're out of court. The arbitrators can go home. There is basically a huge extent to which ISDS, as it was known up until 10 years ago or so, has been gutted under the leadership of the United States. So when we talk about ISDS, we're talking about something which is extremely vague. What will happen is, to the extent ISDS continues to get gutted or disappears, you will go back to the one-on-one deals, as the oil companies had with Libya, and people have with various countries around the world. And under ICSID, which has jurisdiction over contracts, and or ICC or LCIA or wherever you want to go, you'll have arbitration clauses or the people won't invest. Or, as Mark has pointed out, the markup, the cost to the receiving state will go up quite considerably in order to cover the potential risk. So what ISDS are we really talking about? And in the end, will it make a difference?
Thank you. I'm sorry, I'm going to stop questions right there for now, and we're going to have responses to that, and we'll move to our next set of topics, and then I'll open for questions again. Sorry for those of you waiting, but I know that we have a little extra time, but I don't want to run out of time entirely. So any responses to the questions and comments posed before?
I would love to respond to all of those comments, but I'm going to confine myself to a technical response to the political risk insurance question. Because for my sins, once upon a time, I used to represent arms of the US government who provided political risk insurance, or lenders or sponsors who were covered by political risk insurance. There are huge differences between political risk insurance and an independent, impartial forum in which one adjudicates a claim. First, and positively for an investor, political risk insurance, you've got someone promising to pay, and they're usually creditworthy. That's a really nice thing. On the negative side, though, first, political risk insurance does not cover all political risks. It covers only those risks that are defined in the political risk policy. That means expropriation. That means convertibility and transferability of currency. It means political violence. And in certain narrow circumstances, it means breach by a state entity of a state contract. It does not mean fair and equitable treatment. It does not mean denial of justice. It does not mean full protection and security. It does not mean MFN. It does not mean national treatment. Most of the claims in investor-state arbitration are simply not covered by political risk insurance. Second, there's a risk-sharing philosophy, political risk insurance. 10% is never covered when you're talking an official credit agency, because that's what the Barron Union says, that the investor must retain 10% of the risk or more. There's a ceiling on political risk insurance, which is generally well below the amount of the injury. More importantly, we know that because for most political risk insurers, the amount of compensation they pay is book value, invested capital. They do not pay fair market value. That's not what the insurance contracts say. So that means an insured party who obtains this insurance, first of all, the vast majority of claims that mean anything in this system are not covered. Second, they don't get covered for fair market value. They only get covered to get back the capital they invested. Third, for the capital they invested, there's still a risk-sharing proportion. And then finally, anyone who thinks that political risk insurance means that the host state is not subject to arbitration is wrong. The insurer is subrogated to the claims of the insured investor. And you know what? They always have the right to bring it to arbitration. The MIGA policy, they have their own arbitration system. OPIC, they have separate agreements with the individual host states that provide for arbitration. No transparency in that arbitration, unfortunately. No real standards as to how you get a legal decision, but nevertheless, it's arbitration. So anyone who thinks that political risk insurance is an answer for investor-state arbitration, to be blunt, does not know a lot about political risk insurance.
Ushi?
Very quick additional comment on political risk insurance. Actually, these investment protection treaties are meant to produce results also in cases which are not arbitrated. So therefore, the expectation is that the states would live up to the standards they promised there. And these standards come for investors for free. Whereas for the political risk insurance, you would have to be able to pay in each and every case. So this what produces costs which are non-negligible, especially for smaller companies. As to the point for an investor, better rights, this depends very much on the country. So you could probably safely claim that in general, US investors would have the same rights level of protection than they would get under TTIP, and probably you could claim the same for European investors. I would not argue that that would be true in every country of this planet, because unfortunately there are many countries where the national population would not be able to enjoy the protection standards granted in a traditional investment protection treaty. Last point, of what ISDS are we talking about? I mean, yes, that's really a concern to many, and there are discussions in Europe whether it wouldn't have been better to not have started the whole thing at all, because once this model is out there, and once the United States and the European Union might have agreed on a treaty, this might have an effect on future treaty negotiations, and the classical standard, European gold standard, as it was named by some, is certainly providing for a higher level of protection than we see it in the CETA text.
Simon.
I'll just make 3 quick points. First, in response to Mark, I confess that I don't know much about political risk insurance, and it really hasn't been my focus of alternatives. I've mentioned it, but really my focus has been on when foreign investors, make an investment and sign a contract with the government, they should put an arbitration clause in there. We don't need a system of thousands of treaties. We just need foreign investors to take this into account in signing contracts. And then beyond that, I still think a state-to-state dispute settlement system would work very well. 2 other points. This is a response to Miriam. She raised the issue of domestic courts reviewing actions of the executive or legislature. My instinct is that that would go, fine, it would work well, but I don't know. This goes back to my point about we should study this. If there are examples where it's not working, I would love to see them, because then we could figure out exactly what is the problem and maybe how we could address it. And then finally, just about the point, it's made a lot, that there are not greater substantive rights in investment treaties than in domestic law. I'm just not sure that's true, and that goes back to the early point about I don't know what fair and equitable treatment means a lot of the time. It varies by treaty and by award, so I don't feel like I can be certain that there aren't greater substantive rights.
Sure, and so just a few quick points. And so, PRI, the big difference is it costs investors money, right? And so companies don't like to, and bits are free. So I think that's a big hurdle to viewing PRI as a substitute. For Judge Brower's comment, which I think is really raises a really interesting issue. And the question is sort of the comment left me asking myself was, if he's right, and I think he is, that ISDS has been weakened, by the U.S. to some extent over the past few years. At some point, you ask yourself, do we get to a point where why bother? And so if we have a lot of exceptions to ISDS and the substantive protections, then I think it's much less likely that the treaties actually have the kind of benefits we were talking about. And so, in a way, that the cost and the benefits are 2 sides of the same coin. And so in this debate on the left, I think, which is typically the left, focus on, government action as having the potential to be good for society, and they see limiting government's right to regulate in the public interest as being a bad thing. On the other side, typically the right, they tend to focus on government action as being often bad. Right, and so they want to prevent the government from acting, and so but at the same time, so the costs really are what one side views as costs are really what the other side views as benefits. And so if you get to a system in which really the treaties don't really tie the government's hands at all, from the benefits side of things, I mean, then I say this is all a big distraction, right? And then so maybe we drop ISDS from the negotiations and focus on the trade aspects, where we're much more likely, I think, to be able to come to a solution that has clear economic benefits for both sides. I don't think we're there yet, but I think that's sort of the implication if we keep on going down the road that Judge Brower has identified.
Okay, we're going to move to our third set of questions, and I'm going to ask my panelists to be very brief so that we can, some of these things we've touched on already, and so that we can open up to questions from the audience again. So first, this has been mentioned, Jason, are domestic courts a viable alternative to investment arbitration, and what kind of evidence do we need to help answer that question?
Yeah, I will be brief because we've talked a little bit about this. I mean, I think what you want to do is you want to look at how, you ideally want to do an empirical study of how domestic courts handle disputes between investors and states. There have been a few studies from several years ago in the U.S., I think, focusing on foreign investors suing foreigners suing Americans in civil actions and trying to see if U.S. courts are biased against foreigners. But I think it's those kinds of studies that we need and that we just simply don't have. I'm not comfortable asserting that home state governments, particularly in Western Europe and the U.S., are sort of pathologically incapable of treating foreign investment disputes fairly.
Simon, it's sometimes argued, we've mentioned state-to-state dispute settlement as your preferred alternative already, and certainly that is what is included in the U.S.-Australia Free Trade Agreement. How well has that system worked? Or maybe what should I say, since we haven't ever had a dispute in 10 years, does it suggest that the system works at all?
Right, so yeah, I keep hearing that state-to-state dispute settlement will be too politicized. It would never work for foreign investment. You can't have governments getting involved in screening these disputes. But my experience in trade law is the system works pretty well. And it just seems to me that the concerns about politicization of these disputes maybe go back to the 1920s or 1950s when you didn't have an effective international dispute resolution system as a model, and people were looking, when they had problems, they sent in the gunboats. But today, it seems to me, state-to-state dispute settlement system works. We have it in the U.S.-Australia Free Trade Agreement. I can't remember any politicized disputes there. We have it in the GATS, which covers investment. I can't think of politicized disputes there. We have no agreements at all with Brazil and with the U.S. and EU. There's lots of investment. I just don't see the politicized foreign investment disputes that everybody's worried about. So it seems to me that state-to-state can handle all this.
I could mention that Scott Nelson has been trying to get the U.S. government to espouse his claim against Saudi Arabia for 30 years, and that hasn't happened yet.
But does that mean it's politicized? Or, maybe there's not a good
He wanted
case
it
there.
at the time of the first Gulf War,
But
and I don't think that was going to happen.
But maybe that claim shouldn't be brought. I don't know. I don't know the facts of the case.
Well, at any rate, I'm just suggesting that politics does play a role in these some of these decisions. I'm going to turn to Mark to ask whether a TTIP, investor-state dispute settlement, should we have that? Could they accommodate differences between good governance states if we accept for purposes of argument that the EU is divided between good governance states and weak governance states? Must there be one-size-fits-all procedures? Could there be some alternative?
There are two issues here. One is, would it work if one were conceptually prepared to agree to a distinction between good governance states and bad governance states? You can think of mechanisms such as independent measures of judicial independence, of corruption, of rule of law, where, by way of example, there's 7 EU members who rank below the 70th percentile for the World Bank's Rule of Law Index. There are 10 EU members that rank below number 40 for Transparency International's Corruption Perceptions Index. So you could conceive of something like that. The core problem here is the EU. Prior to the European Union taking over exclusive competence for investment, the United States negotiated standalone investment treaties with 9 European member states. It, to my knowledge, and there are many current and former U.S. government officials in the room who can contradict me, to my knowledge, the U.S. has never seriously proposed a standalone investment treaty with the United Kingdom, with France, with Germany, countries that we generally perceive of as good governance states. The reason why we have a problem in TTIP about investor-state arbitration is the EU insists on a one-size-fits-all rule, having taken over exclusive competence. Does that mean there's a serious issue? Well, I'll bore you with one last set of numbers. The European Union issues a justice scorecard every year. The 2015 Justice Scorecard measures quality, independence, efficiency of European member states' justice systems. For purposes of determining the independence of European national court systems, they rely upon the World Economic Forum survey. for that purpose, which puts questions to companies in the particular country about that country's own judicial system. It's not foreigners talking about other countries' judicial system. It's nationals of country X talking about country X's own judicial system. And what is it for the European Union? 2015 survey came out last month. Of the 28 European member states, 13 of them rank below number 54 out of 144 countries surveyed. That means 13, almost half of the European Union member states have 37+% of the world above them. 9 of those states, including Italy, I might add, fall at or below number 70. That means almost half of the world ranks above them. There are 5 EU member states that rank below number 90 out of the 144 countries. That means over 62% of the world ranks above them. I mentioned Italy for a reason. The last time I looked, which was at the very end of 2010, there were well over 2,000 cases pending at the European Court of Human Rights against Italy simply because of the excessive length of judicial proceedings in Italy. The average civil court proceeding in the north of Italy is over 7 years. The average civil court proceeding in the south of Italy is over 9 years. A point that was raised when we were permitting questions, is the EU one judicial system? Clearly not, and there are a large number of member states in the EU that do suffer from serious questions of judicial independence, corruption, cronyism, and non-adherence to the rule of law. If we could get the EU to draw distinctions, that would solve this problem immediately.
Thank you. May I ask my questioners to kind of start preparing yourself to come up to the microphone? I'm going to ask Ursula to answer a last question, and then we'll open the floor to questions from the audience. So, Ursula, would the addition of an appellate body be adequate to respond to the concerns people have levied about ISDS?
Okay. The prolongation of proceedings and the increase of costs both militate against the introduction of an appellate body. 2 different concerns are often mentioned to advance the idea of appellate bodies for investment arbitration. One is inconsistency of the case law, the second is correctness of the awards. With regard to correctness, it's doubtful whether an appellate body is necessarily wiser than the tribunal. Both can be composed of very experienced persons having high legal qualities. There are, as far as now, no different qualification requirements for members of annulment committees than for members of arbitral tribunals. Therefore, the mere fact that another body looks at the case does not guarantee in and of itself a better decision. If one were to increase the number of arbitrators on appellate bodies to 5 or 7, this would also not necessarily improve the legal quality of the decision. There is only one apparent difference in the current system between tribunals and their bodies of review. In arbitral tribunals, the investor may choose one arbitrator, and in the case of agreement with the respondent state, has a voice in the selection of the president. In annulment committees, as well as in setting aside proceedings before national courts, only persons chosen by national states in one way or another because they are judges in national courts or they are on the exit list decide on the fate of arbitral awards. But the fact of selection by a state in and of itself does not make the decision of the supervisory instance more accurate. As far as consistency is concerned, it would be possible to increase it if one appellate body could be created which would be competent for all of the different treaties in place. If each treaty has its own appellate body, it's only a matter of time until there will be conflicting case law of the various appellate bodies. For the moment, it looks like each treaty would provide for its own appellate body. To create one appellate body for all treaties creates a number of problems, one of them being the ICSID Convention, which explicitly exclude any appeal in Article 53. A change of the convention text is virtually impossible, since it needs the approval of all state parties, and to make an interstate treaty has also various obstacles. A better means to achieve harmonization would be the creation of a preliminary ruling facility. Such a system is already in place at the Court of Justice in the European Union, and that's a system which in Europe is considered to be well functioning. One could allow tribunals, before making a decision, to ask this facility in the case of doubt on how to interpret a treaty provision, and one could oblige a tribunal to refer a case to the facility if there is a conflicting case law on a particular question. This would prevent the need to correct damage already done in the form of inconsistent awards, and it would not conflict with the ICSID Convention. Such a preliminary ruling facility could be adopted, for example, like the Ancestral Transparency Convention, since it's not expressly prohibited by the ICSID Convention.
Thank you, and I extend my apologies. We have been told we have to leave. I'm really sorry. I took for granted that the 15-minute grace period would be available to us, but I hope I can speak for my panel to say that we'd be happy to go over to the side and take the questions that Sonia and Tom and others have. And in the meantime, please join me in thanking our panelists for having given a lot of thought to this.